Here's what I don't want you to have: a separate higher tier of civil status under the law. I don't want somebody who has a gender identity and a gender expression to have a first-class status, and my nieces, who are biological women who you refer to as cisgender because you had to make up a word because normal was offensive to you, okay? I don't want men to be able to impose themselves upon my niece's spaces under the idea that you have conjured through this Equal Rights Amendment, which is actually an erasure amendment, it's an unequal rights amendment, to have conjured a path for those men to literally displace the women in my life and the women in my community with dudes who claim to be women. That's what I don't want you to have. And you're damn straight I'm willing to do whatever it takes to ensure that that injustice never occurs. State Representative Walter Hudson here, coming from Minnesota to give you a deep dive into the issues that are important to folks who live in this state and have an impact on the rest of the nation, because these conversations are happening everywhere. So what I want to do today is I want to start off by taking a look at an article that was published in the Star Tribune, which is the local newspaper here in the Twin Cities, bemoaning the fact that in spite of trifecta Democrat control here in the state of Minnesota, the legislative session just came to an end, and they were not able to pass one of their highest priorities, as they described it, which is the so-called Equal Rights Amendment. Now, this is something that I personally call the Erasure Amendment, because that's the effect that it would have. It would have the impact of erasing women as a category under the law. It certainly would have the impact of erasing the unborn as a category that gets any sort of consideration whatsoever under the laws of Minnesota. And that's the status quo, right? So last year in 2023, Democrats passed and Governor Walz signed what they called the PRO Act. That was their signature piece of legislation. It was House File 1 and Senate File 1, which means that that's their way of signaling that this was their highest priority as legislative caucuses in the state of Minnesota under a Democrat trifecta. And what the effect of it was is it stripped civil rights from an entire category of human beings, the unborn. If you are an unborn human being within the state lines of Minnesota, you have no rights. None whatsoever. That's the status quo under current state law. And part of what their so-called Equal Rights Amendment would have done is calcify that into perpetuity. So it would have put into the state constitution that the unborn have no civil rights whatsoever in perpetuity. And to my knowledge, that would have been historic. That would have been the first time in the history of the state of Minnesota that our constitution, our state constitution, would have been changed for the purpose of stripping civil rights for an entire category of human beings. Thank God that did not happen. This was not taken up by the Senate. It was not passed, and it will not be a ballot question in front of voters in 2026. Certainly provided that Republicans retake the majority in the House this fall and that we restore balance going into 2025. Right now, total control of the state by Democrats, and the results bear that out. But what I want to do today is, this article was put out, and as you can see here with this tweet, Gender Justice, which is one of the primary interest groups, obviously, I mean, they can tell you right there in the title, Gender Justice. They're coming from a perspective which affirms all of this gender ideology, gender theory, gender fluidity, men can be women, women can be men, all of that stuff. They affirm that, and they were one of the prime movers of the Equal Rights Amendment. Now, you might reasonably ask yourself, well, why? Why would Gender Justice be interested in an amendment to the state constitution that has the effect of stripping civil rights from an entire category of human beings? Well, that's because that's not all it did. It did quite a bit more than that. They jam-packed this amendment, this constitutional ballot question, with far more than just eliminating the unborn as a category. They also inserted or we're trying to insert all of these different quote-unquote protected categories, which is really a misnomer. They're not really protected categories. What they would be is first-class citizen categories, that if you don't fall into any of these, if your religion, your conscience, your chosen way of life, your expression, your conscience comes into conflict with any of these categories, then you are going to be a second-class citizen under this proposed constitutional amendment. And of course, the signature part of that was the inclusion of gender identity and gender expression into the mix. So obviously that is why Gender Justice, as they call themselves, is deeply upset by the fact that this did not go through and will not be put forward to Minnesota voters as a ballot question in 2026. So the tweet here is, the fact that there is such strong opposition year after year tells you why we need it, said Megan Peterson, Executive Director of Gender Justice, and part of the dogged coalition that helped push the ERA so close to the finish line this year. And so I have not read this article. I thought I would save that as a live reaction for you and me right here, right now. So let's go ahead and click on it and take a look at what Gender Justice has to say in the Star Tribune. All right, so this is written by Jennifer Brooks, who's a local columnist for the Star Tribune. I don't know what, if any, relationship she may have with Gender Justice, but let's go ahead and take a look at the article. So the headline is, Brooks, a sad end of an ERA in Minnesota as legislative session closed. A century on, Minnesotans pick themselves up from the legislative wreckage and prepare to try again to pass an equal rights amendment. Now, right away, we haven't even gotten into the body of the piece, and just that little blurb explanation is incredibly deceptive. So the appeal here, and this really is a central point with this whole equal rights amendment nonsense that they tried this year, is they're appealing to the origins of the equal rights amendment. They're appealing to a century past when the ERA was first proposed. The equal rights amendment as first proposed was a completely different proposal. It's an entirely different proposal. And I know that because on the House floor, one of the amendments that we brought as Republicans was to, in fact, delete all of the language that was being proposed by Democrats and replace it with the original ERA, the original Equal Rights Amendment, which merely said that persons are not going to be discriminated against according to sex. That's what the original ERA was. And if that's what was being proposed, you would certainly see a lot less resistance to it, and would have seen a lot less resistance to it during the Minnesota legislative session. What was presented before the legislature this year was an entirely different animal, and I've already described part of the reason why and how. It included this stripping of civil rights from the unborn, and it also included the elimination of women as a category under the law in the state of Minnesota. The effect would have been, and this bared out in our floor debate, you can go back and watch it, you can see the clips, maybe I'll embed a couple of them here, where Democrats explicitly affirmed that the effect of ratifying their version of the quote-unquote Equal Rights Amendment would have been that women could not have their own sports. Men would be allowed in women's sports. Women also would not be allowed their own private spaces, locker rooms, restrooms, etc. They would have been admitted, men would have been admitted to those spaces under this version of the Equal Rights Amendment. Now, if you think that's what your grandma was going for back in 1970, I think you need to have a conversation with her, because that is very much not what your grandma was going for back in 1970. This was an entirely different proposal. And so again, before we even get into the body of this op-ed, of this piece, this column, you're already being lied to. And the lie is, what I talked about this on the House floor, we hear a lot about cultural appropriation, this idea of appropriating things and misusing them for culturally inappropriate purposes. That's what this is. The branding of the proposal that came to the House floor as the Equal Rights Amendment is an explicit act of appropriation. And what they are trying to do, and what this author is trying to do in this blurb, is appropriate the goodwill that has been built up over decades for that originally proposed Equal Rights Amendment and copy and paste it duplicitously in affirmation of a completely different idea that has nothing whatsoever to do with the original form. So it is astounding that we don't even have to get into the body of the article in order to demonstrate the deception and the bad faith with which this idea was being sold to the Minnesota public. So we get into the body, and it reads, as the 2024 Minnesota legislative session lurched to a close, howls of rage filled the Senate chamber. Traitors, Republican lawmakers shouted across the aisle. They yelled, they booed, they melted down like toddlers at Build-A-Bear. And those were the guys who got their way. On one issue, at least, the clock had run out on the Equal Rights Amendment. Again. The end of an era, the start of the next. Before the dust settled in St. Paul, organizers were planning to try again to place the ERA on the ballot for Minnesotans to decide for themselves. Shall the state constitution be amended to guarantee equal rights? Do Minnesotans have a right to expect their state to protect them from discrimination based on their race, disability, sex, or sexual orientation? Do Minnesotans have a constitutional right to make their own decisions about their own pregnancies, gender identity, and gender expression? The House said yes. The polls said yes. The Senate said yes last year to a similar version of the bill that didn't spell out reproductive rights. And so here again, lots of conflation and deception in the presentation of this. So just let's start with this sentence, this first sentence in this paragraph. Shall the state constitution be amended to guarantee equal rights? We know that question is offered in bad faith. And again, we can point to an amendment that was brought by Majority Leader Lisa Dameth on the House floor that would have, and again, it was a delete all, that would have replaced the language and reduced the question down to precisely that. Shall all persons be guaranteed equal rights under the law and freedom from discrimination? That's a pretty fair paraphrase of the language that was on offer, if not verbatim. And Democrats rejected that. They didn't want to have equal rights. This was not about equal rights for all Minnesotans. And we know that because of what I shared with you earlier. The Democrats explicitly stated that the impact of this would have been to erase women's spaces. It would have been to through the Constitution, forcibly impose men into women's sports and forcibly impose men into women's locker rooms and women's bathrooms. That is not equal rights. That is placing the objective category of women, adult human females, in a second class underneath those who identify as transgender. If you have a gender identity or a gender expression, you would be a first-class citizen under this Equal Rights Amendment, quote unquote. And that is indeed why they so eagerly wanted it. They want to have two tiers of citizens in the state of Minnesota, and they want to ensure that those who profess some sort of gender identity, and that can be literally anything, we certainly know that, that's part and parcel of gender theory. It's all inclusive, it's a spectrum, and it's fluid. You can change from one moment to the next. Which, by the way, as an aside, really does distinguish those categories, gender identity and gender expression, from any other category under consideration. So indeed, they included things like sex, national origin, color, race in this amendment. But those categories are things that, while subjective to an extent, for instance, race is a relatively subjective term, there's still an underlying innate quality to it, right? So I am an African American. That is something that I was born as, and you can tell by looking at me, right? It is something that is identifiable. It is based on objective criteria, even if the concept of race itself is relatively subjective. But gender identity and gender expression, under the terms that it's presented on gender theory, is entirely fluid. You can be a man one day, you can be a woman the next, you can be a dragon, a furry, a shark, who knows? There's no limitations to what you can identify as under this absurd notion of gender theory. And so to take something so divorced from any sort of objective definition and place it in the Constitution as something that takes precedence over these other innate qualities, race, national origin, color, what have you. It just breaks Minnesota's jurisprudence. It would be completely unenforceable, and it would place people who are trying to leverage this new constitutional first-class status within the category of gender identity and gender expression at a fundamental advantage over literally everyone else. Because you could always decide that if your category, if your gender identity or your gender expression isn't adequate to provide you with that first-class status that you need in a given situation, why, you could just change it. And who are the rest of us to question it under the law? And this is something that I pointed out, is that this was really a very poorly thought out provision, even on its own terms, because what it said was that Minnesotans have a right to not be discriminated against in intent or effect. And those two words, or effect, what that means is if you can demonstrate an actual or perceived disparate impact in virtually any category, any conceivable category, then you would have a cause for action under this new change to the Constitution to force the state and potentially other non-state actors, that was another thing that wasn't clearly defined in the debate over this provision, to change their policies in order to correct whatever disparate impact you had identified. And so you would potentially have a situation where, even within the scope of gender identity and gender expression, it's this spectrum, right, where you've got all these different possibilities that you could identify as. Well, you could potentially pit one of those identities against the other. And let's just keep it simple, right? Like trans men, quote unquote, and trans women, quote unquote. What if there's disparate impact between those two groups? Now you're going to have this internal conflict within the trans community where one of those two groups gets to claim that they're being discriminated against by the other, or being discriminated against by the state, because there's this demonstrable disparate impact upon one or the other in whatever category we could possibly imagine such distinction, such disparity manifesting itself. An incredibly sloppy piece of legislation that deserved to die, and I'm very, very glad that it did. And then this part here where it says that the polls said yes. The polls did not say yes. I don't have it up in front of me, but the majority of Minnesotans did not like the idea. There was a KTSP poll. There was a KSTP poll that said that most Minnesotans did not like the fact that this equality language was being bundled up with the pregnancy language, the abortion language. They didn't want those questions being considered on the same ballot question. And there was also polling that indicated that the status quo of abortion in the state of Minnesota, where it is legal up until the very moment that a child draws breath to terminate their life for any reason whatsoever, that is not a popular provision in the state of Minnesota. A majority of Minnesotans do not support that. So this is just a flat-out lie, the idea that the polls said yes, and that that's something that Minnesotans wanted. They did not. She goes on to write, "We're on the right side of history," said Betty Folliard, founder of ERA Minnesota. "We won't take no for an answer, and we will prevail." The National Archives once dubbed the ERA America's most popular, never ratified amendment. And again, it's so deeply dishonest here, what she's doing and what the advocates of this current version of the ERA are doing. That statement that ERA was America's most popular, never ratified amendment, that is in reference to the federal ERA that was proposed years ago. And that federal ERA did not say anything remotely close to what this proposed language and this proposed ballot question that was considered by the Minnesota House this year said. It did not include the stripping of civil rights from the unborn. It did not include the erasure of women as a category under the law and the imposition of men into women's spaces, whether it's sports or locker rooms or restrooms. This is a totally different provision. And so again, trying to portray, Just taking the branding of ERA, taking the branding of Equal Rights Amendment, and trying to conflate support for what it once was, for what it has metastasized into, is deeply and objectively dishonest. And the people who are doing that, including this columnist, should be called out for lying. Listen, there's only two possibilities. You're either lying about what the current version of the so-called Equal Rights Amendment is versus what it was when it was originally proposed, or you're too incompetent to notice the difference. In either case, you are not responsibly engaging with the public discourse. You are being deeply irresponsible, if not malicious, in your engagement with the public discourse, and that ought to be called out. The Star Tribune should be ashamed for publishing such an obvious, demonstrable lie. She goes on to write, Alice Paul, a leader of the suffragist movement, wrote in the first draft of 1923, and again, 1923, do you really believe that in 1923, the women who were drafting the Equal Rights Amendment had gender ideology and gender expression and gender identity in mind? Do you really think that the women in 1923 were looking to strip civil rights from an entire category of human beings, any child who is yet to draw fresh air into their lungs, that they can just be terminated because they're unborn? Do you really think that was the intention of the women in 1923? Obviously it wasn't, and so conflating these two things is an act of malicious deception. Alice Paul, a leader of the suffrage movement, wrote the first draft in 1923, just 3 years after women won the right to vote, and it read, men and women shall have equal rights throughout the United States and every place subject to its jurisdiction. Ladies and gentlemen, I rest my case. That was the original language. Men and women shall have equal rights throughout the United States and every place subject to its jurisdiction. That is not the language that we were presented with, and I'll prove it to you. I'll bring it up here for you to see. This is the current version that was most recently proposed of the Equal Rights Amendment, quote unquote, placed before the Minnesota House. It is materially different and extraordinarily expansive in scope beyond what that original 1923 language was. The column goes on. The last time the archivists counted, about a decade ago, the ERA had been reintroduced in Congress 1,100 times. 1 out of every 10 proposed amendments to the Constitution has been about an Equal Rights Amendment. It came close after the Second World War. Alice Paul lived long enough to see the ERA pass Congress and sweep triumphantly through a swath of state legislatures, including Minnesota, which ratified the amendment in 1973. She did not live long enough to watch it fall 3 states short of the 38 it needed for ratification before an arbitrary time limit set by Congress expired. University of Minnesota law professor Jill Hasday could fill a book with the myths, misconceptions, and misogyny deployed against the ERA over the years, or at least an entire chapter of her book, We the Men, How Forgetting Women's Struggle for Equality Perpetuates Inequality, coming in 2025 from Oxford University Press. Now, let me just say, even if all we were considering was that original language, the original language which said, men and women shall have equal rights throughout the United States and every place subject to its jurisdiction. First of all, that protection is already in law all throughout the United States. That you cannot discriminate against women because they're women in the United States of America. That is not legal. That is not happening in point of fact. And as just one piece of anecdotal evidence, let me point you to the current Speaker of the Minnesota House. Who's that? What's her gender? What's her sex? I think you can tell by the pronouns I'm choosing to use. Who's the current Senate Minority Leader in the House of Representatives? Lisa Dameth. Not only a woman, but a black woman at that. If you pan the cameras around the chamber in the Minnesota House, what do you see? Women everywhere, engaged in the work, cloaked in electoral power, leading on legislation, casting votes, deciding votes on what the laws of the state of Minnesota are going to be. On what basis are you arguing that we're still living in 1923? On what basis are you arguing that we're still living in 1972? This is an absolutely absurd argument. And apparently the columnist goes on to address that. One of the arguments people who are against the ERA will say is, we already have sex equality. We don't need this, she said. At the same time they say that, though, they'll talk about all the terrible things that the ERA will allow, especially abortion. Yes, indeed, because that is materially different and has nothing to do with the original ERA language. Is it possible for the proponents of this idea to make an argument without engaging in illegitimate conflation and deception? Is that possible? I've yet to see it. Column goes on. Over the past 101 years, the ERA has enjoyed the support of presidents and lawmakers. It's been a plank in the Republican and Democrat parties' platforms, but there were always those who balked and fought and dragged their heels just enough to ensure it never happened. There were always supporters afraid to bring race, sexual orientation, gender identity, or abortion into the ERA, fearful that controversy would cost votes and we'd never get a 28th Amendment. Thank you for acknowledging with that paragraph that of the two options I provided earlier, either you're lying or you're incompetent. We can scratch off incompetent. You're lying. You just admitted that this proposal is materially different than the original proposal. And so why are you dishonestly appealing to support for a past proposal which was materially different than the one that is currently being offered today, and pretending as though there's this widespread support for it? Deeply dishonest. The column continues. The fact that there is such strong opposition year after year tells you why we need it, said Megan Peterson, Executive Director of Gender Justice, and part of the Dogged Coalition that helped push the ERA so close to the finish line this year. Even from some of our own folks, we sometimes hear, do we even need this? Don't we already have these rights? She said, look, if we already had these rights, people would not be willing to filibuster to the end of time to bring down the institution of the state legislature to stop it from happening. Clearly, there's something we don't currently have that they don't want us to have. Here's what I don't want you to have: a separate higher tier of civil status under the law. I don't want somebody who has a gender identity and a gender expression to have a first-class status, and my nieces, who are biological women who you refer to as cisgender because you had to make up a word because normal was offensive to you, okay? I don't want men to be able to impose themselves upon my niece's spaces under the idea that you have conjured through this Equal Rights Amendment, which is actually an erasure amendment, it's an unequal rights amendment, to have conjured a path for those men to literally displace the women in my life and the women in my community with dudes who claim to be women. That's what I don't want you to have. And you're damn straight I'm willing to do whatever it takes to ensure that that injustice never occurs. The column continues, Minnesotans have introduced equal rights amendments to the state constitution almost every legislative session since 1973, which was as far back as the heroic researchers at the Legislative Reference Library could dig without actually digging through boxes of paper documents. Most states have equal rights provisions in their own constitutions. Nevada voters added an equal rights amendment to the state constitution in 2022. The ERA will be on the ballot in New York this November. For those without a constitutional guarantee, the past few years, as the Supreme Court overturned Roe and conservative lawmakers legislated against pronouns and targeted trans kids, have been a harsh reminder. The rights you take for granted today could vanish in the next election if you don't spell them out somewhere. Finally, we agree on that final point. Finally, we agree that we do in fact need to spell out in the Constitution that rights must be equal for all people, and that those rights must be adjudicated objectively by criteria that exist in objective reality. That is extraordinarily important. And this is why, and I'll be real honest with you, because there are even people within the Republican space, within the conservative space, that fail to recognize the gravity of this victory, and it is a victory. If we fail to defeat and cast into the ash heap of history this absurd idea that a man can declare himself a woman and a woman can declare herself a man. If we fail to do that, then we are going to be subordinating the cornerstone of all jurisprudence in the Western world. And what is that cornerstone? Truth. The most impactful clause in the Declaration of Independence is, we hold these truths to be self-evident. And the actual truths that follow that up, the actual stated enumerated truths, are less important than that actual root concept of there being such a thing as truth, there being such a thing as truths that are so obvious and so predominant that they don't require further explanation. Men are adult human males. Women are adult human females. Those truths are self-evident. And if you start to undermine and subordinate self-evident truths, then there's going to be no basis upon which to claim any other right whatsoever. That is what was at stake with this fight against the Erasure Amendment. That was what was at stake and continues to be at stake as this fight moves forward. Are we going to have objective reality, self-evident truth as the cornerstone of our jurisprudence, or are we going to turn over our laws to the whims, the literal whims, of whoever has political power? Thanks for watching this deep dive. We will cover more in future days, and I appreciate your patronage. Like, subscribe, share, get the word out. These conversations are important. Take care.